Good morning. Are you Britney Litchfield? Give me just a second to get this printed out. And will your client waive the formal reading of the motion in each case?
Yes, Your Honor.
Ms. Litchfield, in clause number 21-37098, I have a motion to revoke your community supervision. Shows that you were placed on probation December 12th of 2022 for the state jail felony offense of abandoning.
Whoa, pause for a second. The judge is already cutting straight to business. Motion to revoke probation. That's never a good opener. This tells us the court isn't here to negotiate. They're here to confirm whether Britney followed the rules or didn't. And spoiler, probation violations usually stack up fast. Let's keep watching.
A child, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Judge will still abandon, I guess it's 6 and 7 on each motion and just proceed on 1 through 5.
In each motion, 1 through 5?
Yes, ma'am.
It's okay. All right, and then in cause number 21-37099, I also have a motion to revoke your community supervision. Shows you were again placed on probation December 12th of 2022 for the offense of abandoning a child, and that was also a 2-year term in state jail prison that was probated for 5 years. Is that also correct? Each of these cases, the state has elected to proceed on counts 1 through 5 in the motions. They each allege in count 1 that you violated your probation by failing to report to the probation department as directed October 15th, October 31st, and November 14th of 2024. And is that true or not true? Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 in each case alleges that you failed to immediately report to the probation officer your current address. Is that true or not?
Now, this is the critical part. Look at how the judge lists each missed report date like receipts. Missing even one can trigger a violation, but 3 back to back? That's practically a legal avalanche. And the judge isn't emotional about it at all, which somehow makes it scarier. What would you say if you were standing there, getting every failed duty read out loud?
Not true. Count 4 alleges that you failed to provide verification of performing the community service hours that were required. Is that true or not true? And then count 5 alleges that you failed to provide verification of entering and successfully completing the parenting class. And is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts in each case because they're actually true?
Yes, ma'am.
In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Litchfield is not competent?
No, Your Honor.
All right, ma'am. In each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probation. In cause number 21-37098, revoke your probation and reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25-37099, also find sufficient evidence to revoke your probation, and at this time revoke your probation, reassess your punishment in accordance with that agreement to a term of 12 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to...
Okay, big moment here. The judge revokes probation and hits her with 12 months state jail, but runs them concurrently. That's actually a tiny lifeline. Concurrent means both sentences run together, basically like doing one instead of two. If they were consecutive, she'd be doing double. Probation revoked is bad, but it could have been worse.
Possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am, and thank you for being here. Good morning. Are you Maya Sparks?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Yes, sir.
Ms. Sparks, in cause number 25, DCCR 0145, you're charged with the third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? Speak up, please. And then in cause number 25 DCCR 0146, you're also charged with a third-degree felony offense of assault on a public servant from October 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
And it looks like the agreement that you've reached in each of your cases is for a 6-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Sparks is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you...
This is a classic deferred probation setup. 6 years hanging over her head. And here's the twist. Deferred doesn't mean light. It means if she slips up even once, that guilty plea snaps into a full conviction instantly. It's like walking on legal eggshells for 6 straight years. High stakes.
Enters your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back at a later date for sentencing. Mr. Nichols, what is the state's position on bond?
Judge, I'm a little concerned about a PSI bond because of the way these cases occurred. There might be an issue that I do anticipate she at the very least being placed on mental health caseload. I don't think it's a competency issue. I've discussed it with Ms. Holmes, but I don't know if the court's going to decide that either an ISF or a safety program is in the best interest here.
Okay.
The facts in this case involve threatening staff at a school, so it gives me a little bit extra concern. And there was one jail incident in the last week that gave me a little concern as well.
Okay.
Yes, Your Honor. So Ms. Sparks and I've spoken with her mother. Her mother is here. On this particular incident, there was a episode. She had a mental episode where she was not on medication at that time. She is compliant on medication now.
Okay.
And we are asking, her mother is taking care of her child. Her child was attending that school that she went to. And so I do feel that if she stays on her medication and stays compliant, that she would be okay. And so we were asking if the court would consider a PSI bond.
I guess the concern is without the probation order where, has she been to Spindletop before have you gone through Spindletop before?
Yeah.
You are a Spindletop patient?
She's diagnosed bipolar and major depressive disorder.
Okay. So what I'm going to do, Ms. Sparks, just kind of based on also time of the year, I'm going to reduce the bond, but I'm going to have some very specific conditions on that bond. And you're going to have to follow those conditions exactly. If you don't, because you're going to have to give Ms. Holmes proof that you're doing some things that I'm going to order you to do. And if you're not doing those things, then I'll issue a warrant for your arrest. We'll get you back in custody until that pre-sentence report's done, and then we know what everything is that you could potentially need.
The judge is entering full protective mode here. Reduced bond, but strict conditions. Mental health compliance, medication monitoring, Spindletop appointments, and even a no-school order. This is what you call a structured safety net. The court believes she can do better, but only under tight supervision. Will she follow through? That's the real question moving forward.
Was there also any type of, or is there any kind of drug issue, or is it primarily mental health?
It's just mental.
Okay, so Ms. Sparks, I'm going to reduce your bond in each of your cases to $2,500. If you make those bonds, the conditions of the bonds are that you immediately make an appointment with Spindletop, that you give proof of when that appointment is to Ms. Holmes. So I'm saying the day you get out, you make the phone call, you set an appointment, and Ms. Holmes needs to know when that appointment is. You don't wait a week to set the appointment or 2 weeks or anything like that. You set it the day you get out of jail if you make the bonds. Does that make sense? In addition, I am ordering that you remain on your medication. So now it's not just whether you want to or you feel like you need to. It's a court order. And if you don't do it, you're back in custody. Do you understand? So is her mother okay with her living with her? Where's Mom?
Yes.
Thank you, ma'am. And thank you for being here. So I'm going to order that you remain living at your mother's house. You can't go spend the night anywhere else. You can't go anywhere else. You stay there. You go to Spindletop. You get yourself back on track so you can be fine and do this probation and not have any issues. Does that make sense? You are not to go to any of the schools wherever your child or children are going to school. You are not allowed to go there, period. Do you understand? Okay? That's going to, not until I order otherwise. So for now, you cannot go to any school that they are attending. Okay? If somebody needs to pick up and drop off, that's going to be her or someone else. If there's a school program between now and when you come back, I don't care. You don't get to go. Do you understand how serious I am about that? Okay. Any other conditions that you feel
I
like?
think that will cover it, Your Honor.
Okay. All right. We'll see you back
A
at
quiet
sentencing. You
courtroom
can go back with the
turns tense
bailiff.
as Britney Litchfield
Sparks.
faces the judge once again.
And will your client waive the formal reading
Missed
of the
reports,
indictment in each
broken
case?
promises, and
Ms.
probation
Sparks, in clause number
violations stack up
25,
fast.
DCCR
But the real turning
0145,
point
you're
arrives
charged with
when
the
the
third
judge
degree
finally
felony
decides how
offense
much
of
mercy
assault on a
remains.
public servant from October
Britney's passed
30th of
probation for
2024.
abandoning a child
And how do you
unravels
plead to
with
that
every admitted
charge?
failure.
Are you
The
pleading
judge
guilty
revokes
freely
probation
and
sends her to
voluntarily?
jail, but the punishment stops short of
And are you
maximum
pleading guilty
pain.
because you actually did what
Then a
they've
new
charged you
defendant
with?
steps up, and the courtroom braces for a very
Speak
different
up,
kind
please.
of danger.
And
Good
then
morning
in
turns
clause
ominous as
number
Britney Litchfield stands before the court, facing the quiet weight of past choices catching up.
25
Two
DCCR
probation cases
01.
loom over her, both tied to child
4-6.
abandonment, both once softened
You're
by
also
judicial
charged with
mercy.
a third-degree felony
From the
offense of
start,
assault on
the
a public
judge's tone
servant
makes
from
it clear
October
this
30th
hearing
of
is not about
2024. And how do you plead to that
negotiation, but
charge?
accountability.
Are you pleading guilty
Dates,
freely
duties,
and voluntarily?
expectations are read aloud with precision.
Speak up,
each
please.
missed requirement stacking higher against
And are you
Britney's
pleading
already
guilty
fragile
because you did what
standing.
they charged you with?
Failure after failure
In each
is
of these
confirmed.
cases, I have here on the tablet some
Reporting deadlines
documents that
ignored.
have your signature on them that the
Employment
state has
unverified.
marked as exhibit number 1.
Addresses unreported.
Before you signed these, did you go over
Community
them with Ms.
service
Holmes?
unfinished.
Do you fully
Parenting
understand
classes
them?
abandoned.
And do you understand if I
admits each
follow the
violation,
agreement that
her
you
own
made with the
signatures
district
proving she knew
attorney
the
that you will
rules
be
and walked
waiving
past
or
them
giving up
anyway.
any right to appeal?
With measured restraint,
So if I
the
follow
judge
the
revokes
agreement, you can't
probation
change your
and
mind later. Do
imposes
you
2
understand?
12-month state jail
And
sentences,
it looks like the agreement
ordered
that
to
you've
run
reached in
together.
each of your cases
It
is
is
for a
discipline
6-year
tempered with
deferred
restraint,
probation.
a final
There would be a
reminder that
$300
leniency has
fine, and you would
boundaries.
be required to follow all of the
Britney is
rules
warned
and
about
conditions of
firearm
probation.
restrictions
Is
and
that your
quietly led away
understanding?
as the courtroom absorbs the
Do you also
consequence.
understand if you're not a U.S.
Then Maya
citizen
Sparks
that a
steps
plea of
forward,
guilty or no
shifting the
contest
energy
probation,
completely.
there would be a $300
Charged twice
fine,
with
and you
assault
would be
on a
required to
public
follow
servant,
all of the
she appears
rules
less
and conditions
defiant
of
than
probation.
unstable.
Is that your
A
understanding?
deferred probation agreement
Do you
offers
also
her freedom,
understand if
but
you're
at a
not a
high
U.S.
cost.
citizen that a plea of guilty
6
or no
years hang over
contest?
her,
Do you
ready
also
to collapse
understand
into
if you're not a
Pryzell.
U.S. citizen that a